On a bitterly cold January night in 2022, Boston police officer John O'Keefe was found lifeless in the snow outside the home of a fellow officer in Canton, Massachusetts. His body was discovered the following morning, bruised, battered, and partially covered in snow. According to prosecutors, his girlfriend, Karen Reed, dropped him off at a house party attended by other law enforcement officers and their families. They allege that after a night of drinking, an argument erupted, and Reed struck O'Keefe with her SUV, leaving him to die in the cold. Charged with second-degree murder, vehicular manslaughter while under the influence, and leaving the scene of an accident, Karen Reed has maintained her innocence. Her defense argues she is being framed, pointing to a cover-up with law enforcement and inconsistencies in the timeline and the handling of the evidence. The case has gripped the public, fueled by viral social media debates and allegations of a botched investigation. As Reed faces a second trial, the quest for justice for John O'Keefe grows even more contentious and complicated. And tonight, we are live from the courthouse after another day of important expert testimony and allegations that the prosecutor misled the jury. All of this as the retrial of the century continues. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments as we begin another week in the Karen Reed retrial of the century. We're getting close to the end. The evidence may wrap up this week. Obviously, you will see and hear all the developments on your front row seat to justice. For those of you who don't know me that well, you know, I was a prosecutor. I was young when I was a prosecutor, as you can tell from this photo, inside my office, right? It was back in the day. But even as a young prosecutor, I learned a lesson very quickly. And it was something, you know, we got trained to be prosecutors. And I'm trying one of my first cases, and I'm in the room preparing with some of the witnesses. And one of the witnesses, who happened to be a local police officer, asked me, counselor. He called me counselor. I was like, wow, counselor, all right. What do you want me to say? I was like, oh. And it hit me very quickly. You know, think about my training to become a prosecutor. I was like, the truth. Just tell me the truth. That's all I want from you. And that's important because that's your, and it was part of my training, that's your ethical obligation as a prosecutor is to seek justice, and justice equals the truth. The only way we get justice is when we get the truth. And that's your job, that's your obligation as a prosecutor, is to seek justice. It's not to win cases. It's not to do whatever it takes to make sure the accused gets convicted. It's to seek the truth, and the truth is justice. And if you brought an indictment, you have to believe in that indictment. You have to believe that that is the truth of what happened. Yes, all of that. But you can't do it in a way that is deceptive, where you cut corners or kind of, you know, play loose and fast with the facts and the truth. You just can't do that. Now, in this case, in Karen Reed's retrial, the special prosecutor is Hank Brennan. Now, he was a prosecutor. He's been a defense attorney for a long time. The obligations and ethics of defense attorneys much different than that of prosecutors. But as a special prosecutor, you still are tied to the same ethical obligations as a regular prosecutor, which is to seek justice, which is the truth. It's not to do whatever you can to win a case. That is clear. So what happened today? The special prosecutor, and I can say it because it's the truth, right? Misled the jury today. Misled the jury during his cross-examination of Daniel Wolfe, the accident reconstruction expert. That's a big deal. That's a big deal. Let me show you what happened here, because I think it's really important to establish this off the top, because this is a huge moment in this case. This is the moment I'm talking about. Here is Hank Brennan cross-examining one of the most important witnesses for the defense, talking about whether or not there was a collision. Take a look at what happened.
Did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the.
May I approach and retrieve the exhibit, Your Honor?
Yeah.
Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
All right, this is an attempt to undermine the credibility of Daniel Wolfe in front of this jury. That's exactly what this was. By saying, look at there's holes in the back of his sweatshirt. You didn't consider any of this. You didn't consider if he fell. What kind of expert are you? You're not taking a look at all this. There's one big problem, though. One big problem with that piece of cross-examination in front of the jury, showing this jury that this so-called expert didn't even know about the holes in the back of the sweatshirt. Take a look at what Robert Alessi did with this in front of the judge, not the jury.
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. In what I'd like to do, Your Honor, this regards the hoodie. In this regards questioning and representations and questioning by Mr. Brennan. Here is the back
Okay.
of the hoodie.
Okay. All right. Thank you.
It's very obvious that these are cutting holes cut by the criminalist. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022. What Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartman, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolfe, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminal list, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious?
And he continued on with that. So this is important. This is an important piece of evidence, a crucial piece of evidence on a very important issue in this case. Let's get some more insight. Court TV crime and justice correspondent Matt Johnson joining us live from outside the courthouse in Dedham, Massachusetts. The courtroom was shaken today, Matt. So he's calling out Hank Brennan in front of the judge, not in front of the jury, but in front of the judge. What is Hank Brennan's response? And then what did the judge do about all of this today?
Yeah, I was in that courtroom, Vinnie, completely quiet. You could cut the tension with a knife. Alessi is pounding on the podium. Some of the O'Keefe family members, they are shaking their heads during all of this. And then Hank Brennan, he stands up and has a response for the judge, Judge Beverly Cannoni. Here's what he said.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. The court should strike the questions and the answers. And you should instruct the jury they are to completely disregard any questions or answers about the holes in the back of the sweatshirt.
Okay, so the jury takes, or the judge rather takes this under advisement. The jury walks back in, 9 men, 9 women, 18. They are seated in the box. And then Robert Alessi holds up that sweatshirt with the cuts in it that we now know very clearly were made by the state criminalist. And the judge says this to the jury.
So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023.
And even after the jury left for the day 29 of this lengthy trial, we're in week 8 now, Robert Alessi stood up and he said, Judge, we may have more arguments about this tomorrow. That instruction might not be good enough as to what was read to the jury. So we may hear more about this, Vinnie, tomorrow morning on day 30.
Yeah, wow. What a moment. What a gift to the defense from the prosecution, making a blunder like that. Whether it was purposeful or a mistake, it's equally bad. It's equally bad. Okay, the defense, we're in the defense case. More witnesses for them. They called a private investigator. Tell us about that.
Yeah, their other private investigator that was going to testify about this fell ill, so they hired somebody else, and this is John Teddeman, who went to 34 Fairview, the crime scene, and he took a lot of measurements, and he also took photographs. And then he tells the jury that he also poked his head into the garage area, that side door, where the red one, and here's what he saw.
In the course of doing your further work that you were asked to do in this case, did you peer inside the garage?
Yes, I did.
Did you see concrete steps and a ridge there and a hard concrete floor?
Yes.
Sustained. Jurors, disregard that answer.
That's going to become important tomorrow, especially for more of the forensic pathologist testimony. But so he takes more measurements at 34 Fairview, this private investigator, and he's instructed to take the measurements from the driveway, the mailbox area, and he takes 3 important critical measurements, including these. So the mailbox to the main front door, that's 65 feet, 9 inches. Then he takes another measurement from the mailbox to that middle door where that double window is right there. That's 70 feet, 1 inch. And then to the red door that leads you directly into the garage, the double garage there, from the mailbox, it's 78 feet and 3 inches. I see it right here. I checked my notes. And so this is going to be really critical for the defense case in chief and their whole theory, because remember, Officer John O'Keefe, his phone registers dozens of steps, possibly up to 80 or 82. And then there is the 36 steps that were taken before the final lock event on his cell phone. So they haven't quite connected the dots, at least with this particular witness, but we can especially believe that they will do so in their closing argument.
That's huge. All right. Who is Dr. LaPosada?
Right, so this is Dr. Elizabeth LaPosada. She's well known in the area as a forensic pathologist, long history, and dozens, if not, she said hundreds of autopsies. Well, she is the counterpart to medical examiner Irene Scorti-Bello, who testified for the state. Cause of death, according to Scorti-Bello, was hypothermia and blunt force trauma injury to the back of Officer John O'Keefe's head. That's how he died, according to her. But LaPosada is not disputing that at all. She says that she's adding to it, and today we heard a little bit about that because she was embellishing on how she believes he fell. Take a listen.
You indicated that the wound pattern suggested a ridge or ledged surface.
Yes.
Could you explain that in more detail, please?
Yes. So if I were looking at it, I would see the break in the scalp. Then I would see several sort of irregularly placed scrapes of the skin that kind of look like pencil marks. And so that means that something with granularity he hit first, then it moved up a little, broke the scalp, and then moved on a little bit above that.
Would you expect to see that if Mr. O'Keefe had fallen backward onto a perfectly flat surface?
No, it has to be a surface that has some small ridges in it to make those little vertical patterns.
No, remember, that testimony was right after the testimony from the private investigator who said that he noticed the steps when he poked his head through that red door, the side door at the garage. And then that's what was objected to, sustained, and stricken. So again, this is really going to the defense alternate theory here that he entered the home and was injured there, Officer John O'Keefe.
Yeah, and it's new. This is new. The new door to the garage. A lot of the new stuff in this retrial. Okay, Matt. I mean, explosive day inside the courtroom. Any reaction after court today? I'm sure someone had something to say today.
Well, again, as we have to remind our viewers, everyone is under gag order except for this defendant, Karen Reed, for her retrial. So outside on the courthouse steps, a lot of questions, but she did answer one about the hoodie and the call for the mistrial. Take a listen.
The holes in the shirt were entirely misrepresented by the prosecutor. January 29th, and they came from May by the criminologist.
And we're approaching the end, Vinnie. They were going over scheduling for quite a bit after court today, after the jury was sent home, and this could be the final week of testimony. We're hearing that experts are going to be on the stand for probably the next day and a half, maybe 2 days, for the defense for their case in chief. It's going to be a short rebuttal case, according to Hank Brennan today. He's going to call 2, maybe 3 witnesses. That's going to be maybe a half day. So we might be in closing arguments before week's end. But you never know with this trial.
You never know. But I'm not hearing anything about Brian and Brian being called, Albert and Higgins. So that's interesting. All right, Matt Johnson at the courthouse as things are winding down. Thank you so much. Let's bring in our think tank tonight. Joining us, longtime Massachusetts attorney, knows a lot about this courthouse, Rick Grundy. Also with us, criminal defense attorney Darnell Crossland, also a New Englander when he's not in the Dominican Republic, and family law attorney Jennifer Brandt. Great to have everyone here tonight. Okay, I want to start first. Just give me a number. All right, no explanation, just a number. 0 to 10, how serious or how much of a problem is the misleading of the jury by Hank Brennan today? 0 to 10. Rick Grundy, give me a number.
3.
3. Darnell Crossland.
10.
10. Jennifer Brandt.
9.
9. All right. Rick, you're the outlier. Why is it only a 3? Why is this no big deal, misleading a jury?
Well, the explosion happened outside of the jury's earshot. You know, I quite frankly, I don't even think the judge should have allowed Attorney Alessi to be the one holding it and parading it in front of the jury. So I think the impact on the jury is far lesser than it is for us that got to see Attorney Alessi in his typical verbose Othello, a human thesaurus, go through it and pound it out. It's a huge issue down the road. And so I'm talking at this point, I don't think the jury sees it as that great of an impact.
All right,
but
Rick, I got to get around the horn here real quick.
But
Darnell,
it's there for closing.
Closing arguments, right? Closings. Darnell, why is this a 10?
I think it's a 10 because the jury's already looking to the prosecution saying you have a burden here. You have a burden, as you said, Vinnie, to seek justice, not convictions. And when they do something like that, the jury's already saying, okay, cool, we were trying to give you the opportunity to do it, and now you're lying to us. And I think they hold that against them. I agree with counsel. I think the prosecutor should have held it up and apologized.
Wow. All right, Jennifer, you got it at a 9.
Yeah, I think it's a big deal because I think the fact that the defense is holding it up, I think that's more impactful than the prosecutor if he had held it up. And I think the judge telling the jury just to totally disregard that testimony, to disregard those questions and answers, I think that it makes the jury start to wonder what is going on here. Somebody was not doing something right. And the fact that Alessi's walking around parading it around, I think it makes them think that something was up with the prosecution. So,
and he's wearing those black gloves while he's doing it. He's got the black gloves on.
Exactly.
Yeah, I think I agree with everyone. I think I agree with everyone because I think we're all kind of in sync on this. And Rick Grundy, I think it comes down to the closing argument. Alan Jackson can say, ladies and gentlemen, he tried to undermine the credibility of my expert by telling you that he knew nothing about the holes in the back of the sweatshirt. But right away, within 3 seconds, he knew those holes weren't from being dragged. And now you know that because we had to correct what the prosecutor was trying to tell you. When the prosecutor tried to tell you those were from the ground, those weren't from the ground. We all knew. Now you know. Dr. Wolfe knew in 3 seconds that they weren't from the ground. So I think we got a big, big, big issue here during the closing arguments. All right. Think Tank staying with us. When we come back, some complicated questions on cross-examination, plus coming up next hour. Tonight on Vinnie Politan Investigates, the battle of the experts, as we take a closer look at all the experiments done by both sides and ask the most important question: what do they actually prove?
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on Court TV.
Lori Daybell, doomsday cult mom, convicted killer, and now defendant in yet another high-profile trial. Will this be the final chapter in the saga
of the doomsday cult mom? The Lori Daybell conspiracy trial, mornings on Court TV.
If the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm, if it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, this was an important moment of the cross-examination because prosecutors are trying to explain the wounds on John O'Keefe's arm and the punctures in the sleeve. And what he's trying to prove is that the arm hits the taillight once, breaks it, but then as it pushes through, that's how you get the cuts. But the expert is saying once you hit it within 1/10 of a millisecond, they're all moving at the same speed, so it won't contact it again to create those punctures and those wounds. All of that resulted in one of the most complicated questions I've ever heard asked on cross-examination today. Take a look. Try to understand the question.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Objection, I'd like the source.
No.
Dr. Rentschler, do you agree with that?
Objection.
So I'm going to allow it strike source.
Do you agree with that?
I'm sorry, can you repeat?
I can. If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, specifically if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection.
I'm going to allow it.
In reference to the greater damage, we're talking about damage to the arm?
Do you agree with that phrase?
The best way I can characterize it is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Do you agree with that?
I'm going to allow it.
I'm going to read this one more time, okay?
Okay.
Would you agree if you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
Okay, I just want to put it up on the screen because when you put it all together, you've really got to follow it. And what I'm wondering is the jury able to follow this question and what it really means? If you have an arm that's actually struck at 25 miles per hour, you're going to have a significantly greater damage, especially if there's a tail light that shatters. So you have the tail light coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the tail light, then parts of the tail light are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that, Darnell Crossland?
Yeah, I would agree that when you have to struggle to explain something, just give it up. You lost no points in that one.
And I think it's an important point he's trying to make here. But Jennifer Brandt, I'm wondering if it's getting lost in the sauce here.
I think so. And then when he had to ask it a number of times, the same question over and over, and he sort of changed that a little bit a few times, it got even more confusing. I don't think anybody knew what he was really talking about.
Vinnie, you're Italian, so what type of sauce?
Yeah, what kind of sauce, right? Oh, the Sunday sauce, of course. Let's take a listen now because it's relevant to part of the experiment. I think he's quoting one of the reports. But let's take a look at this and see if it makes more sense, Rick Grundy.
And now, stop please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
Well, if it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed, like this says, by the arm, by the broken taillight, isn't it?
It's going to move with the arm.
Okay, Rick, is he making his point through cross-examination here, Hank Brennan, in trying to explain the injuries on the arm, the cuts, and the punctures in the sweatshirt?
So first, Vinnie, it's Sunday gravy, and you know that, and you should be ashamed of yourself. But he's having a real difficult time of it. But I noticed that on your show within the last couple of nights, you had a good-looking guy from Massachusetts, and I think he was trying to make the same point and got jumped on. And I think the point is that if the arm isn't necessarily all that extended and he gets rammed with this and is pushed along with the car, those jagged edges are going to dig into the arm. He's having a tough time making that clear. But I think what he's doing is he's trying to appeal to that kind of common sense. I don't need an expert to tell me this. You guys are digging too deep into this. Here's a way that these cuts could have happened, plain and simple.
But in this case, Darnell, in the experiment, those cuts and scrapes don't happen. And I guess he's pointing towards the forklift as preventing them from happening.
Yeah, so that's first of all, I'm always jealous when I see these type of demonstratives because I never get a chance to do them. And you might get a chance in closing, but I'm jealous of these courts that allow this greatness. And also, they must have a lot of money. In terms of the forklift thing, if you have to say this demonstration would have worked perfectly and you would have been able to see where he fell, but for the forklift, then it's no demonstration. I mean, if it's not going to show the jury how he fell naturally and make the complete point, you can't say this is a great demonstration, but for the forklift, because then now you leave the jury to have to make up the rest, how he would have fell, how he would have been injured. it's not a good demonstration.
What do you think, Jennifer Brandt? Do you think the jury is going to walk away from the experiment, the direct, and the cross and say, hey, yeah, I get it. His arm would have been damaged by the taillight, and he would have had those scrapes and would have had those punctures?
No, I don't think so at all, because I think if you look at this demonstration, it explains it even less, because he gets hit on his arm by the car, but they're saying if he didn't have the forklift there, you know, it would have been different. The forklift is holding him up. So you would think that if he gets hit like that, he would probably just fall down and not really get injured by those pieces of taillight. They wouldn't have gotten into his arm because he would have sort of fallen back, possibly. So I think it just raises a lot of questions. And for the jury, I agree with Darnell. I mean, you really can't see what happened. You see him getting hit, but then they're saying, well, if he wasn't held up by the forklift, something else would have happened. And we don't see that. So I think it just makes it even more confusing.
Oh, it is confusing. It confused the first jury. They were hung, allegedly, on all 3 counts. Maybe just count 2. We don't know. All right, think tank staying with us when we come back. The defense has a new theory now, and it was unveiled today. Did John O'Keefe go inside 34 Fairview? And if so, was it door number 1, door number 2, or door number 3?
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows, and then if you can see the little red line, that is a side door that goes into the garage.
The side door going into the garage, door number 3. It's a big deal. Take a listen to the private investigator hired by the defense who took some measurements on the distances to reach each of those 3 doors.
I was asked to measure from basically the mailbox area of the driveway to the various entrances to the house.
Did you take those measurements?
I did.
Okay, if I'd like to take them one at a time. First, did you measure from the end of the driveway next to the mailbox all the way to the main front door, which is not depicted on this photo?
Yes, I did.
How did you measure it?
I used my wheeled measuring device, and I walked directly across the lawn to the front door, well, to the bottom of the front steps, and then used it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if I
think you got it right, sir.
Okay.
Next, did you measure from that same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen?
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt, right next to the grass, towards the house from the mailbox and the edge of the street, towards the house. I took a left onto the brick walkway, proceeded along that walkway, then took a right to the walkway that you can see right there, heading directly to the door, and went up onto the little decking area, and then those 2 steps directly to the doorstep.
Okay, so you walked essentially almost the whole length of the driveway?
Yes.
Before you took the left to get to where the steps start going to that second front door?
Yes.
And then went up to the door itself?
Yes.
Do you recall from your memory what the measurement was?
I believe it was 70 feet 1 inch.
And finally, did you measure from that same end of the driveway near the street next to the mailbox to the red side door, which is the pedestrian entrance into the garage directly?
I did.
How did you measure that?
I did the same thing, walking directly from where the mailbox and the driveway intersect, basically, all the way up the driveway, took the same left onto the red brick pathway, took a right to go towards the front door, went up the one step that you can see, and then instead of going up the next 2 steps, I took a right directly towards the garage entry door.
So essentially the same path of travel, it's just you didn't go straight into the second front door, you took a right to go into the pedestrian entrance to the garage.
Correct.
And what was the measurement that you discovered having done that?
I believe it was 78 feet 3 inches.
All right, so why do all these feet and inches matter? Take a look. Do you remember John O'Keefe's phone data? Take a look. Keep scrolling. Let's go all the way down to the bottom of the phone data. I'll tell you the most important thing to the whole thing. Here we go. Look at 12/52/16, end of health event, 36 steps, 25 meters. That's about 82 feet. 82 feet that he's walking. Let's bring back in our think tank, Rick Grundy, Darnell Cross, and Jennifer Brandt. Jennifer Brandt, he's walking about 82 feet. It's 78 feet 3 inches to the garage door. The garage door has the steps on it, matches the marks on the back of the head. Is this compelling, or are they reaching here?
This is very, very compelling, Vinny, because it sort of all lines up. Where he went, why he had, hit his head, it kind of all fits together really nicely. So I think this is one of the most compelling things I've heard in this case thus far. I think this is a really good witness, really good evidence. I think it makes a lot of sense.
Do the numbers add up, Rick?
Yeah, the numbers seem to add up, but I'll tell you, this is the one thing, it's a nice paint job they got done on the house, too. My concern with it is I think the defense has changed their strategy enough to really to keep in the encampment of reasonable doubt. And now it seems like they may go on a path where they overextend themselves, put a separate story out there, and then you have the jury saying, well, we got to pick one story or the other.
Darnell, in the first trial, it was at door number 1 or door number 2, and he went down to the basement, and now it's door number 3 to the garage.
Well, this is a funny thing. In a civil case, the plaintiff has to prove their case by preponderance of the evidence, which means just tipping the scale slightly. In a criminal case, prosecution must prove their case beyond a reasonable doubt. And there's an old saying that even though we don't have the burden as defense attorneys, if you were to prove your case by preponderance of the evidence in a criminal trial, then that means the prosecution cannot prove their case beyond a reasonable doubt because you just tipped the scale. So I think this was a nice tipping of the scale today. I love it.
It's fascinating how much has changed from trial 1 to the retrial, Jennifer Brandt. And the prosecution has changed the time of the collision, for goodness sake. They've changed it by a significant number. And now you've got the defense, introducing door number 3. How does the dog get into the garage? I'm wondering.
Yeah, I don't know. That's what I mean. There's so many questions. I think with the more we have this trial, the more this goes on, the more questions we have. I hope it doesn't go on to a third time because it'll be a whole new trial, more evidence, more information, more questions. I don't think anybody knows. Well, some people know what happened. We certainly don't know what really happened.
Somebody may know. I think somebody, but, the jury's got to figure it out. Rick, do you see a problem here with, the dog bites and the garage? Do they have to put the dog in the garage now?
Well, again, this is the thing. My advice is I appreciate very much what Darnell just said, but I genuinely think that that's what happened in the first trial is they came out and tried a case different theory, equally hard as the jury. Juror said, we don't know what happened. Well, in your proper mind, listening to the instructions, that means it was a not guilty, but they felt they had to pick one story or another. So yeah, is everybody waiting in the garage ready to pummel this guy upon entrance? If you go too far down that road, it raises a lot of questions, and maybe you end up in that same position where well, we don't believe the defense, so does that mean we believe the Commonwealth? And you lose that reasonable doubt in the Sunday gravy.
Oh, man, he's hitting that hard, the Sunday gravy, because he's just wrong. Darnell, let me ask you. Chloe the dog, they're leaning into the dog bite for sure. Now they're leaning into door number 3. You have about 20 seconds here. Are they getting too specific?
You know, it's about doubt. So I don't think they are. If the prosecution can't make their case clear that it's proven beyond a reasonable doubt, we're just gonna muddy the waters, and that's what we need.
You know what else is muddy? Gravy. It's brown. It's not red. Thank you, Darnell, for clearing that up. Rick Grundy, Darnell Crossland, Jennifer Brandt. Great to have you on the program. We'll see you again real soon. When we come back, I will reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, there are no eyewitnesses to the alleged murder of John O'Keefe, and that's one reason why expert testimony may be the key to the case. But what have the experts actually proven? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
Karen Reed is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county.
Come at me.
The Karen Reed murder retrial. Live coverage weekday mornings, 8, 7 Central on Court TV.
Welcome back. Time to reveal something else you need to know tonight. Let's take a look at what's happening in the world of crime and justice. Yes, the Diddy sex trafficking trial. Big development there. We've got some evidence to play for you. This is a voice memo from Diddy to one of the accusers in the case, Jane, who has been unnamed and unidentified. A threatening voicemail. Let's take a listen.
Hey, I really don't know what's going on with you, but I just want to just give you a heads up that I'm about to really disappear on you. You feel me? I'm not going to be playing these games with you at all, at all. So I don't know. You think you silent treating me, and you think I'm going to be, nah. You'll have a rude awakening. You'll just have silence. And ain't nobody threatening you, and I ain't trying to go back and forth with no woman. You know what I'm saying? I'm telling you, I ain't got no time for no games. Where my life is at right now, I don't have no time for no games, baby girl. Me and you can be mad, I can have a spat, we can have whatever. Then after that, you better get on your job. That's really, that's all it is. Cause you got me on my job. Nah, it ain't never gonna work like that over here. You know what I'm saying? I was trying not to leave this message, but you have left me no choice. So either you go in the direction of like moving on and like that, or you like just like have me just keep moving. Ain't no threat, I'm just being clear. I can't do this with you every time you get upset.
All right, is this evidence of a domestic dispute or is this evidence of racketeering? That's a question for the jury. Take a look, folks. We have a missing child who needs your help tonight. This is Ehlina Zariahna Harvey, missing from Chanute, Kansas, just 16 years old. If you see Ehlina, please pick up the phone, make the call, make a difference. 911, 1-800-THE-LOST, or you can call the Chanute Police Department in Kansas. That number's on your screen right now. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.